I'm delighted to be able to introduce Dr. Nigam. Dr. Nigam is a fellow alumnus from the National Law School. I've had the benefit of being his student, his first batch, where he taught at NLS. So Professor Nigam did his LLM in tax law from NYU and his doctorate in philosophy from Oxford University. He's taught at NLS. He was also taught at the Azim Premji University for the inaugural LLM batch. And yeah, delighted that he's the dean of the law school at BMU. And exciting times for the law school. And Professor Nigam, I'd like to invite you to take the second part of this presentation.
Thank you very much, Ritvik, for that introduction. Can we go to the next slide? Yeah. So thanks everyone, and a very good morning to everyone. In some ways, this is one of the most exciting days for me since I joined the law school, because it's a culmination of a series of conversations that I've been having with a number of people over the last 1 year, and that to me is really the most important part of this conclave. That its conclave is just one day, but it's actually a result of a series of conversations over a period of time with people from various modes of careers and lives. This entire idea of inviting lawyers to tell us about legal education, which looks to me right now as something that ought to have been done years ago, is something that came out of a conversation I had with the Chancellor and the President, who were very keen when I joined this law school to align legal education with legal practice. Now, as I said, as I'm saying it to you now, it doesn't look like it's a very radical idea. In fact, probably should have been done years ago. But our legal ecosystem is in a very interesting space right now. For years, it's been the case that law schools are living in an island of their own, and their idea of what legal education is has in some ways atrophied and has not kept in touch with the legal realities and with the realities of the marketplace. And I think that's something that really needs to be remedied. It's a systemic issue for us. It's a systemic issue that legal education has not taken account of the kind of skills and trends that are available in the market. And that is a major problem, I think, for any law student who goes to law school today. I mean, I think Ritvik always makes it a point to tell me that what I taught him is actually outdated in multiple ways. I taught Ritvik. I'm proud to have been his teacher, nearly 20 years ago. And when I taught him indirect tax, there was no GST. There was only excise tax and sales taxes. So substantively, things have moved on, and then procedurally, things have moved on as well. There were not at least not the kind of legal research skills that we have now through Manupatra and LexisNexis and Westlaw and SEC Online. All the things that Ritvik actually put in the basic bracket, not in the, he had 3 brackets in this previous presentation. And one of them, it started with basic, intermediate, and advanced. And I was shocked to note that he has put legal research skills in the basic bracket, which was not even there when I was teaching Ritvik. So if you can see on the slide, and you can see how the extent to which things have moved on. That what was considered revolutionary, say 10 or 15 years ago, is now in the basic bracket. It's not something that you have to have. Even and I just wanted to make one more point about that. Ritvik, sorry, if you could just go back to the to that basic bracket. I just want to make one more very interesting point that came to my mind. It's interesting that Ritvik has put, in addition to Word and PDF, Excel and Excel sheets knowledge, something that lawyers rarely learn in law school. In fact, I don't think there's any major law school that actually teaches Excel quite seriously. And then we find out when we go to any reasonable corporate practice that a basic understanding of Excel, and in fact, an advanced understanding of Excel would be even better, but a basic understanding of Excel is required for every lawyer. So yeah, Ritvik, now I think we can go back to the slides. So I think it's really important for us, therefore, to understand how to align legal education with legal practice. And so when we went on this survey, we were very keen not only to ask how technology has changed legal practice, but also ask lawyers, what does it mean for legal education? What does it mean? What do you require of young lawyers entering the profession today? Right? And any thoughts and comments and decisions that we understood through this survey is crucial to us as a feedback mechanism for us, right? And this feedback mechanism, I think, should be there at not just at the law school level, but much like at other schools in our university, it is there at all stages in all schools of the university, whether it be management or engineering, that we need to seek feedback from the real world, from the practice world, in order to figure out exactly how we train our students. And here I should take just a bit of a break, if you can indulge me, the audience, and talk about the very purpose of a law school, right? So there's a great divide in the philosophy of legal education. On the one hand, a lot of legal education inspired by what happened in the UK and in America is considered as giving a broad liberal-based knowledge to students. That's one of the main motivations behind the BALLB integrated course started by Dr. Madhav Menon in the 1990s, of which I am a product, and Ritvik is a product, and many of the panelists here today are products. So that kind of the integrated 5-year BALLB, and of course now it's become BALLB, and then other BSc LLB, BBA LLB, etc. But the BALLB was the kind of model on which plenty of other law schools have been built after the 1990s. And one of the primary motivations behind that model was to give every lawyer a broad-based legal education, right? An education that situates the role of law in the wider context of liberal arts, be it economics, be it political science, be it sociology, history. I'm giving you a catalog of subjects that I learned when I was a student in the 5-year integrated program, and it's the same thing 25 years later. Our students at the law school that we are building and the law schools elsewhere are learning the same catalog of subjects. They're learning in the first 3 years of their life, they're receiving a broad-based legal education. Some reason that philosophy that illuminated the 5-year program seems to have taken a life of its own and seems to have dwarfed the other major reason law schools are there for, which is to inculcate important legal skills, or if I may call it, skills that are relevant to the legal profession for lawyers. So in other words, it is in some ways, some people feel that the liberal education or the background of liberal education that permeated the 5-year program is at variance with the idea of skills that, legal skills that students have to learn, and that the BALLB course is for the students to learn about life and about poetry and about allied subjects like history, economics, political science, and then they start learning about practice when they go actually into practice. And I think that's not the right way of looking at it. I think the BALLB course, whilst providing a very important liberal understanding, um, situates the law students in a situation or in a place where they also have to learn, in fact, as an integral part of the program, important skills that they need to take forward in their legal practice. Right? It cannot be that the law students depend on learning these skills only when they enter legal practice. I mean, legal practice teaches very important stuff to law students, but it cannot teach them basic skills on their own. The skills that are required, some of which we'll be talking about in today's presentation as well as in the panels that follow, are skills that have to be learned when you're in law school. Otherwise, it gets not just difficult, but almost impossible, virtually impossible for the law students to develop into successful lawyers. So this divorce of sorts between liberal arts education, which permeated the 5-year LLB course, and skills-based education, I think is unfortunate. And I think one of the reasons, one of the insights of the survey is that we must bridge that gap, that while the BLLB 5-year course is an important liberal arts introduction to the law, it must also contain within it a mechanism to teach important skills to the students. Now, and that's what we'll be talking about for the rest of this presentation. So when we took this survey, what we asked them was, you tell us what successful young lawyers need to do, right? Somebody entering the profession. We understand that a lot of things you learn when you enter the profession, you cannot learn it unless you have done some practical work in a law firm or in litigation. So it happened to me as well. I mean, when I went to my formative years of legal practice were in New York. I worked at an international law firm in their tax department. It was a trial by fire for me in some ways. I was just fresh out of law school, and I went to the LLM tax program at NYU, and then I had to, immediately after that, work on really kind of complicated international tax matters where I had to give opinions to people. And so the things that I learned that were important for me, and I couldn't have learned it unless I actually practiced. But there were other things that I think I could have learned while in law school that would have helped me in my legal practice. So when Ritwik and I were talking to law firms and asking what kind of skills you require, we noticed immediately that there is already there a mix of what we might call traditional skills and what we call so-called new age skills. Right? That, I mean, I don't think they are so new age. I think they've been there for a little bit of time already. But let's, for the purpose of discussion, divide that into traditional new age skills. So as you can see on the slide, 94% of the participants have been talking about traditional skills. They've been saying research and analytical skills are important. That's what you need to learn in law school. So if you want to learn, if you have an issue, legal issue, you need to learn how to identify a problem, a legal problem. You need to identify where to go searching for solutions to that problem, and you need to know how to analyze those solutions. This is fairly traditional, mainstream, almost Bloom's taxonomy kind of pedagogy. And that's still very important, right? So we need, and that's what happens in the first few years. You need to learn research and analytical skills in any subject, and it's been taught, it has to be taught at law schools. But what's, I think, not taught very well, and this is what came up in our survey, is the attention to detail and the accompanying oral and written communication skills that are important. Right? So it's important, therefore, that we make sure that students acquire the opportunity and the means to become detail-oriented. No high school student comes into law school with detail orientation. It's a skill that needs to be taught. Right? And so in order to ensure that you go through all the provisions of the statute that are relevant, lay them out in proper order, and then you're able to state a solution for each of the issues that you have identified is a detailed orientation that you learn when you go to law school. You don't learn it before you go to law school, right? I see that on a day-to-day basis when I'm teaching my students. I just taught a short GSG introduction class to students at the university. And the first thing, when I give them a problem, the first thing they do is they give me a solution as if the solution has come out of nowhere. So if I tell them what is the tax on this particular transaction, they say the tax must be this. And so I tell them that's not the way to answer the question. For every legal question, you must start with the legal provisions. You have to go to the statute, identify the statute and the statutory provisions applicable, and then try to lay a thread from there to the facts that are given you on hand. And that's the kind of what I say detailed orientation that really comes out of training. And that's important. I think it's not just knowledge dissemination that's important, or it's not just mere basic research and analytical skills that are important, but we need to pay attention to detail. See, an aspect that appears almost ordinary, right? You better be careful, is another way of putting it, but it's something that I think a lot of young lawyers and certainly law students miss. If you, Ritvik, can we just go ahead, please? So the other interesting thing that came out of the survey is the situating law in context skills that were important for law students. So the two really important skills that the survey came up with was that the lawyers should be able to understand and anticipate client needs, and that commercial awareness is an important skill for lawyers. This is something that I think is crucial for all law students, because unless they understand the law in context, they will never be able to solve a legal problem. But how do we even translate what I've just now said into a practical legal education model is a challenge, right? So take a simple example. If we are talking about contracts, we don't start with the Contract Act or the provisions immediately. What we start with are the kind of business issues or commercial issues that the contract is trying to solve. So I start my contract law classes by telling people, my poor students who are already puzzled by me, I tell them contracts is for allocation of risk. That's what contracts do. Forget about the Contract Act for the time being. Think about a contract as a means to allocate risk among parties. And then I give them a practical solution, a practical problem. I tell them, look, we are talking about entering into a contract, a long-term contract to build a bridge or to develop a building. And then what are the risks involved with respect to this contract for either of the parties involved in it? There could be price escalation, there could be labor strikes, there could be some delays by one of the subcontractors. How do we ensure that the contract provides for this risk allocation? And it is in this context that we are talking about ensuring that the Contract Act regulates this behavior in a certain manner, right? If we don't understand the context for the Contract Act, there's no point understanding the Contract Act, right? So this idea that you need to anticipate client needs and the idea that there has to be some kind of commercial awareness is an idea that is at the heart of how to practice law successfully and in a relevant manner. In fact, the BLLB course or the BBLLB course has got means at its disposal that are especially relevant to this issue. And so we have our students learn economics, learn business, learn management, learn some part of legal history. And all of these are relevant in understanding law in context, right? In understanding a problem first, and then understanding how law relates to that problem. One of the partners in my law firm, when I first started out in New York, told me that every good lawyer reaches stage in their lives where the law kind of fades away to the background. Right? And what's really important is, as a business matter, what needs to be done. And what he meant was not that we ignore the law, but that we work in such a way that we now enable the law to solve corporate problems. In his case, corporate problems. It could be used in any other context. Right? And that's a very interesting way of putting it. That the law kind of, for a good lawyer, the law is the scaffolding in which you're able to build something for your client. And that's what we mean when we say, how do we anticipate client needs, and how do we understand commercial awareness? Next slide, please, Ritvik. Thank you. So the following on with that idea about skills and commercial awareness and client needs, the report mentioned that we need direct practical application, some practical exposure, contract drafting, pleadings and procedures, while at the same time prioritizing the fundamentals of law subjects. All very important and relevant stuff for law schools. As I said, research and analysis and fundamentals of law subjects are really important traditional issues for us. But in addition to that, we need to ensure that we increase the commercial awareness of our students, and as well as the ideas of a client needs, by giving them an experiential learning education. We already do that at our law school. We certainly see that in many other law schools as well, which is that in every class or in every course, the practical elements of the course are integrated into what they're doing. Contract drafting, pleadings, procedure. Those are just examples, by the way, from the survey. But we could talk about the same thing in almost every constitutional law, which is the great liberal domain of the law, still involves some practical application and some experiential learning. And we are planning to invite lawyers, constitutional lawyers, to our constitutional law classes in order to ensure that they don't just hear about Article 14 and Article 19 and Article 21 in the abstract. What they do is they hear about it through lawyers who might have actually worked in those areas. So it's really important that we have that kind of practical application. Next slide, please. So how do we, and this is something I think that we'll continue talking after my presentation in one of the panels, but how do we operationalize what I've been talking about, what the report has been talking about, right? And there are a few pointers here that I wanted to present to the audience, and certainly we can, each of these can be taken forward in greater detail in the panels as well as later on in our conversation. And you can see we need to design courses to develop critical techniques, right, to question why a phenomenon is the way it is, and enable students to evaluate alternatives. So again, my poor first-year law students, I make them suffer a bit in even their what they might consider as a relatively easy course. So they go to tort law and they say the tort law is full of very interesting cases. Let's have a little bit of fun. Then I say, yeah, let's have fun, but let's talk about why tort law is what it is. I mean, why is it that people are punished for negligence? Why is it that a negligent person has to be punished? I mean, some people can't help being clumsy. Some people can't help not paying attention to things. Why is it that the law says that if they do something wrong, they need to be punished for it? Why should they pay compensation? Right? So we start off with the Donovo versus Stevenson case, and we say, why is it that if you find a snail in your can of a soft drink, why do you need to hold the can manufacturer responsible when it might well be that it was just bad luck? Right? And since we start, but you see, we ask that question because we want the students to understand and debate ideas of responsibility and fault, and in fact, ideas of blame. And then we ask the students, can we do something different? Do we think that tort law always has to be about responsibility and fault, or can it be about no fault tort liability? So we go into no fault insurance for in motor vehicles, and we say, look, why can't we have that paradigm or that model? You consider the alternative, right? And we do that in the first year. right, in the first few weeks of the classes. And we do that because we don't want them to think, as many high schoolers are prone to think, because of the way our education system has progressed, that there is a clear-cut answer to everything that they just need to know, and then their life is going to be sorted. We don't want them to think that way, because in law, certainly in areas of law like tort, there are no clear answers. There are problems and there are alternatives. And it's important that lawyers understand, the law students get the ability to understand what that alternative is. And there's no point teaching them in that fashion unless we then start designing assessments where we ask them to solve problems and address challenges, right? So this is where we make sure that we kind of take forward that conversation that we have been having into the exams as well. And we build assessments that help students address different perspectives and complex problems in law and society, right? And these assessments, therefore, are complementary to what we are trying to do in critical thinking. And the critical thinking is complementary to what some of the issues of the survey have said, which is that, of course, you need to know the fundamentals of the law, but we need to go ahead. We need to have some kind of awareness of the different kind of issues that are at the heart of legal problems. The next slide, please. So my view, and I think it is shared by the rest of my faculty, is that the law curriculum should help students think deeply about meeting law and policy challenges, and through relevant electives. And this is how we can take advantage of the multidisciplinary aspect of our university. The law curriculum should enable students to understand coding, drone technology, AI, blockchain, biotechnology, etc. Right? And the whole idea for doing all this is because law students should be able to translate new problems into traditional legal issues. Right? So a traditional legal issue is somebody has an accident, who's responsible for it. But the new problem is that there could be a driverless AI-powered car that is the cause, immediate cause of the accident. And so we translate those traditional legal issues into, we translate new problems into the traditional legal issues. So the idea of responsibility is not going to go away. Right? The idea of responsibility in the law, whether it is tort law, criminal law, contract law, it's not going to go away. There's a wonderful course that I did as a part of my BCL at Oxford, which I think is loved by most of the people who did the program there. It's called the Philosophical Foundations of the Common Law, and at that point of time, it was taught by a famous professor called John Gardner, who sadly passed away recently. And we could see when we did that course that how some ideas permeate or trespass across different domains of the law, and it's up to the student to figure out how those domains are connected with each other because of those issues. So the idea of responsibility is an issue which permeates contract, tort, and criminal law, right? And it is up to the student to figure out how to synthesize these concepts across these domains. Next slide, please. So in addition to talking about how students should conceptualize law and how they should have critical thinking, I think that the law curriculum, following on from what has been stated in the Vahura BMU report, holds students accountable for deadlines on papers and essay submissions, conducts frequent examinations, and has strict requirements and deadlines on internship and placement application and processes. I call it the skill of effectiveness. So I've written a piece on legal education that says that, of course, there are skills that are important for lawyers. They have to be able to communicate effectively. We have been talking about that. They have to be innovative. They have to be empathetic. They need to understand what it means to work in teams as well as contribute to each other's success. But in addition to all that, they also should have the skill of being effective. It's a skill that is missing, I think, in a lot of lawyers, in fact, a lot of professionals, and I would say a lot of academics as well. probably academics are the most culpable. Um, what we're trying to do, therefore, is we're trying to solve this last mile problem. We're trying to say that there's no point of a student being skillful in communication and being innovative and being knowledgeable if he or she is not able to complete tasks that are given to him on time. Right? Time management is important. And we kind of make sure that, and that's what we should be doing. I think all law schools should make sure that this idea of time management, the rigor of the law school process, is maintained throughout. I've mentioned in one of my writings that one of the early success of the National Law School in Bangalore was that all students had to complete 60 projects over 5 years. They're basically doing written assignments every 6 weeks. It was a treadmill. It was something that had to be done, and there were deadlines there for every 6 weeks for the students with no respite in sight. So it was, and I think that really helped hone the skills of law students and made them aware of the importance of sticking to deadlines. And these are almost what you might and I might call trivial matters that actually make a huge difference in the end. And as I said, all of us are culpable of not doing it. So we might be not doing what we are asking other people to do. But it's a really important skill, though. It's an important skill to be able to stick to deadlines and time management. And that's an important skill that should be taught, and not taught when you start practicing law, should be taught right over the 5 years of the law school. Next slide, please. Right. So here we come to this idea that the idea that that the traditional skills, which are in the T-shaped paradigm that we're showing you, is the straight line, and then there are the non-traditional skills, which is the line parallel to it, and we notice it is important. It is not that we are doing away with the idea of fundamentals of law and drafting and negotiation and research and analytical skills, but it's equally important now to look at project management skills, technological proficiency, time management, skills of the sort that we would have thought is something that the student has to learn when he starts practicing. It's up to the law firms or the litigating lawyers or others to teach the student. And we believe that that's no longer the case, that law schools, through their curriculum and their pedagogy, have to also address maybe not all of these skills, but at least a substantial part of these skills have to be addressed in the law school itself. I have mentioned 4 of them in some of my writings. I think communication is key. I know that one of the participants in the panel that will come later to Dr. Menaka Guruswamy believes that it's really important for lawyers to write clearly and precisely. That skill is very important for her. She believes that that maybe other things can be taught, but that skill of getting her ideas across is a skill that needs to be learned systematically right from the first year of law school. Similarly, law schools, the students should actually learn to be innovative. I gave you examples. I said talking about responsibility, talking about allocation of risk. The students must be ready to have some, because everything that they come to life later on will not be from a textbook, and therefore they have to learn to be innovative in their thinking and applying traditional legal concepts to new situations. They have to be empathetic. They must become constitutional lawyers, not just in principle, but in practice. They must learn or imbibe the idea of equality and fairness. And last but not the least, they must be effective. Right? They must be able to ensure that what they set out to do, they actually do it. Right? And that's not something you should wait until you go to a law firm or to a litigator's office to learn. That is something that you must start thinking about right from the beginning of your law school. So thank you very much, Ritvik. I think we have come to the end of the presentation. I just want to leave you with the thought that we are at a stage right now where I think for the first time, law schools and law universities are trying to figure out what we need to do to our syllabus, our curriculum, and our pedagogy in order to be better aligned with what we want our lawyers to be. And I think the BMU Vahura report is an important step in that direction. I want to end this presentation by thanking the president, the vice chancellor, and all my team members who helped me conceptualize this idea and implement it. And I also want to thank Ritwik, who, after having suffered through my classes, still had the courage and the grace to come and work with me again after all these years. So thank you very much, and over to you, Kavita.